right, we're going to move on to our second case for the morning on oral argument. It's in the matter of RP, and if council would state their appearances, please.
Emily Adams for the appellant mother.
John Peterson, Assistant Attorney General for the State of Utah.
Good morning, Your Honors. Heath Hackey with the Office of the Guardian ad Litem.
Very good. You are all veterans here. I see 12 minutes on the clock. That tells me that you reserved 3. Is that accurate?
Yes, Your Honor.
Does anybody have any questions before we proceed?
No, Your Honor.
Ms. Adams?
Thank you, Your Honor. Emily Adams for the appellant mother. This is a statute of limitations case. The biological father moved to assert his paternity in child's life 2 years too late. This court needs to answer essentially 2 questions. First, was mother's appeal timely? And second, which statute of limitations, if any, applies to biological father's paternity petition? Turning to the first question about whether a mother's appeal is timely. In January of 2023, the district court issued, it granted biological father's motion to intervene. And the court granted that motion to intervene because it determined that biological father was child's father. That was just merely a step in this case. That was not a final and appealable order. It merely allowed the biological father to become a party in the case and to participate in the proceedings. In abuse, neglect, and dependency proceedings, they're generally divided into 2 halves. The first half is the adjudication portion. So DCFS files a petition, and the question becomes, who are the parties in the case? Who are the parents, who are the children, and what did the parents do to bring the children and the parents under the jurisdiction of the juvenile court? And then the second half
So
of the...
can I interrupt you? Just I want to make sure I'm following.
Yes,
You're talking about the order granting intervention.
yes,
And you've laid it out in your brief. If that motion's denied, it's final. But if it's granted, it's non-final, right?
yes.
Does that change the contour as to an order to get biological testing or an order of paternity? Because wasn't there an order of paternity before the motion to intervene? Or kind of
Yes.
simultaneously, but they're out there, right?
Right, so you have, BioDad filed a motion for genetic testing back in May of 2022, and the district court said, I can't do anything with this motion because biological father is not a party to the case. So then the state filed a motion and said, okay, we would like biological testing, and the court said, kind of winked and hinted to biological father and said, generally when we get these motions, it's in concurrent with a motion to intervene. So the motion to intervene was the only way that biological father could become
I
part
asked
of
that
this case.
question.
Yeah.
But along the way, there was an order of paternity, right? Or a finding, or
It's the same order, isn't it?
It's the same order.
the
It's
same
the
order.
January
It's the
2023
yeah.
order, and the court says in that order, and it's an addendum A of our brief, the court says in this order that biological father is the father of child, and the court then grants biological father's motion to intervene in this case. They're all
this
together.
comes to my question. Can that be severed is my question, I guess,
Oh, right.
jurisdiction wise.
Can it be severed?
And so what I'm getting at is the question was there a final judgment as to paternity that would have run from that order? Do you get
Right.
what my question is?
Yes, I get what your question is.
In other words, if you have a beef with a determination of paternity that's been declared, do you have to appeal within the time frame for that? Or can you wait till the end of the case and say, oh, juvenile court, you got it wrong on that? Do you understand my question?
I understand your question, and it's a complicated answer.
It is.
Because I think it's a complicated issue, Your Honor.
I think if we asked this question on a bar exam,
I think it would be excellent.
everybody would be like,
Everyone would cry.
that, yes, they
do.
would.
It's all right, I'm sure we all cried when we wrote this. So there's no case law that I can find where the paternity, you have separate paternity actions that are generally brought in district court, right? And those, when there's a decree of paternity and child support, those are separately appealable. But in the juvenile case, the juvenile court only has jurisdiction over determinations of parentage in the context of an abuse dependency proceeding or a termination proceeding. So it's wrapped up into this proceeding. In this case, because they were all litigated together as part of the motion to intervene, the father could not be a party to this case unless he was, biological father could not be a party to this case unless he was first adjudicated as the father. And I think that goes to the first half of the abuse, neglect, and dependency proceeding, where we're determining who the parties are and who the children are.
But it didn't though, because, I mean, what you're saying is that finally, when biological father gets adjudicated in the case, basically, that's the final order
Yes, that April
from
order.
which to appeal from. But the January order was also an adjudication order, and in it, the court adjudicated as CM as the father of child. That seems to be a pretty final determination to me. It certainly changes the relationship between child and that person.
It does, Your Honor. And the thing is, finality in juvenile courts, proceedings are pretty mushy, as we all understand
Yes.
here. And so there's some things that we need to think about. It's a pragmatic analysis, and it looks at the substance and not the form. That's what In re JE says. If you look at what does this January 2023 order do, it just allows father to intervene because he's now the adjudicated father. It doesn't give him custody. It doesn't take away custody or reduce the rights of mother. It doesn't change the placement of child.
But those are the orders that are not final, right? The custody orders and the shelter hearing orders and the stuff that comes prior to dispositions, right? And those are not the final orders. What seems to be the really final decision here is that CM is adjudicated as this child's father.
Right, and so that the problem with that is that all it does is it allowed him to become a party to the case and then figure out what was going to happen in these proceedings. It was a necessary step to adjudicate father, and the adjudication order, as this court has recognized, is a final order.
But if you're challenging that, if which we're all here for, challenging that decision, shouldn't that have been challenged within 15 days of the January order?
No, because the adjudication order is the final order, and the motion to intervene, the case law is pretty solid that a motion to intervene is simply an interlocutory order. And this whole context of his termination of paternity was in the context of a motion to intervene. I'll also note that the GAL has constantly said that we are taking too long in these child welfare cases. They're taking too long, they're taking too long, they're taking too long, that we need to have swift permanency for the children. And I think that there's good reasons for that. If we were to add another final order that needs to be appealed, then that would just extend the time of these child welfare proceedings. And that doesn't seem to make sense when that type of determining who the parents are is just a necessary part of the adjudication process. When we get to the adjudication order, the court adjudicates biological father as the father and says, okay, you're a party, you're subject to the jurisdiction of this court, and now we can move forward. It makes sense that all of that, under a pragmatic perspective, would be wrapped into the adjudication order, and that we appeal the adjudication order and not the January 2023 motion to intervene order.
And this may be a weird question, but because finality is sort of, as you pointed out, sort of mushy in child welfare cases, is there a policy, some sort of underlying policy that like you said, suggests that we should determine that mother appealed from the correct order, rather than try and find that we don't have jurisdiction?
Right, I mean, I think, that, well, the policy is that, I keep on harping on, we have these two halves of these types of cases, and the first half is determining who are the parties, like who's under the adjudication of the district court. The only way to get there is to adjudicate a parent, and these people as the parent if there's like a father out there that hasn't been adjudicated as the father. And so it's just a necessary step to the adjudication order, and it can be appealed at the time of the adjudication order. It doesn't make sense if we are truly concerned about swift permanency and speeding these cases along, then we should just allow an appeal as of right at the time of the adjudication order. We shouldn't be creating these necessary adjudication. We shouldn't be creating rights of appeal earlier on in the case.
But as I understand it, all the parties agree that if father had lost, at the January
Yes.
order, then he could have appealed, and it was a final appealable order at that point.
Yes.
And,
Yes.
and that's true with respect to the mother's motion as well, because the January order not only granted the intervention in finding him the father, but also denied the mother's motion to disregard the genetic testing, right? So it's more than just an intervention order. And so I guess my question is with respect to the disregarding the genetic testing, why isn't that ripe at the time that the court rules on the father's motion and says, you are the biological father, we are going to accept the genetic testing? Because at that point, it really does alter the proceedings in juvenile court, right? As you've pointed out, he now has the right to participate. He now has to be part of the entire process. And what mother's fighting is that he's part of that process. So why isn't that ripe at that moment?
Well, because all of those motions were brought in the context of determining whether the court should grant the motion to intervene. So it was all wrapped up in this motion for intervention process. And in the hearing where the court was granting the motion for, let's see, hold on one second. There were multiple hearings on it. So mother filed her motion to disregard genetic testing in November of 2022. And then in December of 2022, that's when the court determined, granted father's motion to intervene, denied mother's motion to disregard genetic testing, and just did it all in one big section. So I think we just look at, this is all in the context of father trying to become a party. All of these motions are in the context of father trying to become a party. In the end, it's a motion to intervene, which is, when it's granted, is an interlocutory order. Just moving quickly onto the statute of limitations issue. I know that I have very little time, but
Well, I think we're gonna ask you some questions about it, and so
Yeah.
we're not gonna
We're
charge
okay.
that.
All
We're
right.
not
We're
gonna
not
charge that
gonna-
against your rebuttal, so maybe I could
Fantastic.
start with the questions and you can
Okay.
backfill. Is that all right?
that sounds fantastic.
It's interesting that, I'm gonna jump to your fallback position, which is that if this specific statute of limitation, if we were to read it as the state, as some of the parties are, that you have to be a signatory to this declaration, and if you're not, then it doesn't apply. Your backup position is then the catch-all applies.
Yeah.
Okay. The catch-all provision has been litigated for decades.
Ever.
And one thing's pretty dang clear, and that's that it's waivable. So if you have a waivable affirmative defense of a statute of limitations, how can it ever be plain error for a court not to apply it?
Right.
Do you see what I'm?
Yes, yes.
Okay.
Well, in this context, plain error isn't probably the best fit, but the parties did argue the 4-year statute of limitations over and over and over again, and they kept on bringing up the 4-year statute of limitations. Oftentimes, it was in the context of the section 607 and 609, but they did argue the 4-year statute of limitations should apply in this case. For example, in 1686 of the record, and then back again on 2028 of the record and 2030 of the record. They kept on arguing that the 4-year statute of limitations apply. What's problematic about this case,
It
Judge
sounds like
Mortensen?
you're super close to conceding on the plain error angle, though. Am I misreading that? or-
I am super close, yes. But I will say, Your Honor, that the court never reached the statute of limitations issue. The court resolved on standing, which is completely separate from statute of limitations. It never reached it, even though the parties argued it. So I think that we have a problem, even before we get to statute of limitations, that the
Right.
court, even though it was argued and it was briefed multiple times, the court never reached it because it seemed to conflate standing and statute of limitations. I also wanted to note just briefly that the parties talked about plain error, but we didn't really brief the applicability of plain error, because when we filed our briefs 6 months ago, there was a case in front of the Utah Supreme Court in Ray AM that addressed the applicability of plain error in child welfare proceedings. Unfortunately, right before Mother's Day, our client suddenly died, and so the court mooted that case. So if this court is interested in delving into the plain error territory and whether plain error applies, I know my client, and I'm sure the other parties would be willing to do supplemental briefing on that issue.
But my question more assumes that plain error exists.
Yes.
And then asks the question, how could it apply to a waivable affirmative defense? The nightmare that's going on in my little head is that if we were to hold that that exists, then it would seem that it extrapolated out that every district court on every criminal case would have to sua sponte undergo a statute of limitations analysis of the case, or have a risk of being reversed on appeal under a plain error standard that they should have seen this plain error thing. It doesn't seem to be a good fit with an affirmative defense. Does that make sense?
Well, in a case though where an action would be completely barred from going on, I
That's-
actually don't have a problem.
That's how statute of limitations work,
As long as it works in your favor.
Right, as long as it works in my favor. Right. But I think this is great. As long as it works in my favor, it's fantastic. But yes, I think the parties were consistently arguing the 4-year statute of limitations. When it bars a claim, I think it should be plain error. And when we, and if not, then we've got ineffective assistance of counsel. Trial counsel obviously was concerned about the statute of limitations here. He made some arguments about the 4-year statute of limitations and should have realized that the catch-all also applied. If your honors would like to go into Castro, into the discussion of Castro, does anybody have any questions about that and how it applies to this case? Be happy to talk about it. Okay, all right, your honors, let me ask that this court reverse.
Okay, thank you. Who's going first? Are you just splitting time?
I think we're
down
gonna
the
split
middle?
the time up in the middle approximately and see how that
Perfect.
works, but. And may it please the court, John Peterson on behalf of the state of Utah. The state doesn't necessarily really have a horse in this race other than just the proper application of the statutes. And probably my biggest concern really is the idea of, and I think which counsel touched on, is having too many final orders in a case. Just that every single new order, which is appealable as a matter of right, is a large delay. And
But let me ask you, isn't it a pretty significant difference in how the case proceeds forward if we have a biological father who's adjudicated as such and participating, right? I mean, once he's granted that motion to intervene and declared to be the biological father, the proceedings change, right?
Oh,
Because
clearly, yeah.
right? I mean, that they're different because we have a biological father who's there and participating. And so while I appreciate the concern about the timing and delay, we have very different proceedings. It's kind of a fork in the road, if you will, whether we have the father or not. And I read in your brief that, everyone concedes that if the father lost, he could appeal. So it's hard to understand why the reverse isn't true, where, mother clearly lost at that stage because she had wanted to disregard that genetic testing. Why that isn't a final order on both sides of that coin.
yeah, it does seem to be gray. My best response is that the way I look at most of the test has always been whether it affects the status of the child, but also it seems to be a little bit of a you're in and you're out. The adjudication, do we have adjudication, do we have jurisdiction? Termination of parental rights, are we done? Permanent custody and guardianship orders, just dismissing, terminating jurisdiction. It's kind of a lot of it seems to revolve around the court's assertion of jurisdiction and whether it exists or not. And the unique thing about our cases too is that, the adjudication timelines are very strict. And so having the appeal go from the adjudication rather than from the intervention paternity determination, they're not going to be really very far apart. And that's why I'm loath to create another final order in there where there's obviously going to have to be a already determined final order in there. And the genetic test, it's kind of a weird, it's like intervention, but it's like a super intervention. So
That's super innovative.
Can I ask you though, and because my perspective must be skewed, right? Because I see the world from our court's docket's view, which doesn't reflect the real world in some ways, because there are a lot of things that happen out in our legal landscape that generally just don't get appealed. And so, you know what I'm saying? There's
yeah.
that kind of thing. Generally, when there's a paternity order that's by virtue of genetic testing, at least from my view here, that doesn't get appealed that much. So my question is this something that would really happen, that if we were to have that say that that's a final order that needs to be appealed, would it really create the havoc that you're talking about? Do you think people would be appealing those left and right?
And, you know, and it's fair.
Generally, and this is all just,
Yeah.
I don't have any scientific basis for this, but generally, people know who they've engaged in intercourse with, and so when the genetic testing comes back positive, it's usually not the greatest revelation in the world. And, but sometimes there is a legitimate question about who the father was, but then it's settled. Here's the DNA test has shown it. People seem, in my experience, at least in the appellate records that I've reviewed, to then move on and say, okay, we understand that's the lay of the land, here we're gonna go. I'm just wondering how much, because you're
The
telling us we
practical
shouldn't
effect,
do this
yeah.
because it's gonna create this great havoc, and my question is, do you really think so?
And, you know, and I think you are, I mean, practically speaking, I mean, if you look through the records of a bunch of juvenile court cases, you're gonna find fathers coming in, fathers coming, I mean, this is not an uncommon occurrence.
Right. But what I'm saying is, would people stop at that point and say, no, I'm gonna appeal that? This genetic determination or this determination of parentage?
Or should they, right? Like, should that be the time when they, if they really truly are contesting that? I mean, you can't really contest the
The biology.
biology, but you can contest the court's recognition.
But let's say you did have a decent fight. Let's say
Yeah.
you were like,
There
no,
were,
that
there were
testing is-
competing DNA
Yeah,
results.
yeah.
Okay.
There's 2 declared fathers. That's a great one. It seems to me that let's take that hypothetical that you actually have
This is the law school exam that maybe
law
is a
school
little more
examination.
interesting.
You
Yeah.
have 2 fathers, or 2 people that have both have genetic testing saying they're the father. If you didn't appeal, that seems to be crazy to say that that's not the threshold point, that you need to do something, because it's going to affect the case moving forward in such a substantial way, right?
I mean, if you, in a case of having multiple claims to paternity though, you would have a loser, and that person would have a right to an immediate
Right.
appeal, which would necessarily encompass the winner as well, just because there can only be one. Yeah.
Right, right.
I mean, in the end of the day, so, I don't know, I mean, I do think it's a little bit, I mean, it's odd too, in that, I mean, as Judge Christian Forster pointed out, I mean, it's, in most of these cases, this is not so much legal as science. I mean, there may be reasons in some cases to disregard paternity, but the way that, our law has evolved is that, by and large, allowing people who are biological parents into the case is approved in most cases.
Well, and also this question, which is also maybe more of a policy question, because Mr. Hackey's gonna get up and discuss this with us from the child's perspective. We're talking about biological father's interest, mother's interest. What is child's interest in this determination? I mean, she is, now has a biological father when she thought that person was no longer in the picture. Does that interest contribute to determining finality for these purposes?
I mean, and it certainly, I mean, it shows the importance of this issue. I mean, and this is an odd case, and you're not gonna have a case really where the actual declarant father's interest is so de minimis as this one. I mean, it's a highly unlikely, I mean, just because, I mean, there really just is no interest there whatsoever. The guy, he hardly made it to a year in their life, and he was never there. He was in prison when she was conceived. He was not father. But another case where there's been somebody in her life, whether she's really thought who is the father or not, I mean, it's upsetting. It's a change. It's a dramatic. I mean, that's why some of these factors that do allow you to disregard paternity in certain cases can be, significant. So it is. In another case, it's going to be a much more important decision than this case.
But which makes me lean towards a result that this was a final decision, that to be contested, it was ripe at the time that it was made, rather than waiting for custody adjudication decision 3 months down the road. The significant impact on child was this determination.
Yeah, I mean, I guess it's a weighing of, I mean, the statute requires an adjudication within 60 days. So, is adding that 2 months rather than instantaneous, in light of adding a whole another appeal in every case where you've got paternity, I mean, my feeling is that given that the adjudication must follow quickly upon this determination, wrapping it into the adjudication is reasonable. I guess another question, I mean, we had a recent decision in this court about the specificity of notices of appeal too, and whether or not one has to specifically call into, to appeal from that particular order if they want to, use the adjudication as a jumping point. So that, which is another, I'll leave that to Mr. Hackey, because I think that's more
Yeah.
his position he's been arguing.
Well, and I want to give you your time, but I also want to give you, I want your, even though you mentioned the state doesn't really have an interest in this, I mean, this does seem to me to be, when we're interpreting the statutes and how we read them, give me your best argument as to how,
The merits of the 608 argument,
Yeah,
I mean, the way I read it is, I mean, there is, this is not the case that, the section 608 was designed to address. That is the case where you've got somebody who has been acting, or apparently has been, in all intents and purposes, the father, the parent figure, and it's designed to allow, sort of an out, and not to remove someone who has an established relationship where it's gonna really harm the child. But I mean, given that where the declarant father is well deceased and never ever established any sort of relationship with the child, I find those factors just to be, irrelevant. And really, this is a case of genetics, and you've got somebody out there who is the child's biological father who should at least get in the door. Whether or not he is parent material is another question.
and that's not what we're deciding today.
Yes. And I guess I'll leave Mr. Hackey if there's no more questions.
Perfect.
Thank you, Your Honor.
Mr. Hackey, we will be liberal with the clock, so you'll have your time.
May it please the court. I think the biggest, and I appreciate the court's questions on the issue, counsel's compared this to an issue of intervention. And there's been discussion about his right to intervene and when he is allowed to intervene, and I think counsel used the term allowed. The court's adjudication regarding parentage didn't allow him to intervene. That would be a motion to intervene. It required him to intervene. At that point in time, the court established him as the father, and that fundamentally changed the landscape of the entire case. Yeah, there might be additional disposition orders, there might be additional custody orders down the road, but at that point in time, he was dad. And as Your Honor pointed out, that mattered to the child as well. It mattered to the father, it mattered to the child, it mattered to the juvenile court. At that point in time, unlike a motion to intervene, if the court grants a motion to intervene, the party comes in. If on the second day the court terminates jurisdiction, that no longer has a meaningful effect. An adjudication of parentage is different, right? Because even if the court adjudicates that parent at that day as dad, in this case, and then terminates the jurisdiction the following day, the court, at the next time a petition is filed, has to identify him as dad. It's not something that he motions to intervene again. He has a right to intervene. And more importantly, my client, has a right to see him as father. So it's not a motion to intervene. And that's why, in this case, it's a threshold issue for us, because it fundamentally changes the landscape of this case. I think the court's points are well taken in that it should have been appealed because the child too had a right to have that appealed in a timely manner, and it was not in this case. And that goes to this court's jurisdiction to hear it. So the argument that it's just simply a motion to intervene, I think, is misplaced. It fundamentally changed the responsibilities of the juvenile court, whether in this case, it fundamentally changed the child's right to have that parent involved, and it fundamentally changed the dad's right to be involved in the case. He was no longer opting. If something was filed 2 days later, he had a right to be there once that was adjudicated. It doesn't go away with terminating jurisdiction. And so that's the big point that we want the court to hear today, because it goes to the issue of jurisdiction wasn't timely appealed. Your Honor had pointed out what would be the effect of this, how often would it happen. I think that this case is unusual in that the adjudication happened months before, the adjudication of parentage happened months before the adjudication of neglect. That I think is a bit unusual in child welfare. A lot of times they happen close in time. But even if it pertains to the court's docket or anything else, it still matters for these kids. Whether it impacts the docket or whether it impacts anybody else, we're talking about the relationship between, in this case, a biological father and his child. That matters, regardless of the docket. And I don't imply any disrespect to the court mentioned the docket, but it is unusual in that it took place early on, but I think in most cases, this would not happen.
Well, that was kind of my point. My point wasn't being insensitive to it.
No.
My point was the opposite argument is that it's going, by recognizing that there was a need to appeal it as ripe at the time, that if we do that, then we're all of a sudden throwing something into the cog of the machinery of juvenile cases, that we're gonna keep seeing these appeals. And my question really is that really gonna happen that often? I think you're telling me no.
In my experience in dealing with these cases, this is probably one of the first times I've seen it with this much time in between. But the equally important to the court's docket and how long in achieving permanency in a timely manner is getting the right result. So even if it takes a little bit more time and folks are willing to waive the timelines, the important thing is getting the right result. And in this case, it meant that the child's father actually involved in the case as a matter of right.
Doesn't that go against the need for finality speedily in this case? Because if you're waiting to challenge the paternity determination, now CM is in the case, right? And not only does he have rights, there's the potential that there could be a relationship between him and his child, right?
And I think that
So don't you want to answer the question of whether he's properly dad?
Correct, and I think that has to be balanced with the child welfare timelines. I think that under 608 and some of the other statutes that are talked about, I think that balance is in place in terms of their ability to come in within a certain period of time and establish that. And I'm not putting to the court that the timelines don't matter. They do. We want permanency. But in this particular case, we don't want to rush permanency at the expense of having the right outcome and not acknowledging this father as the father. The other thing that I would like to briefly touch on is the statute of limitations. And for the most part, we echo what the state, and I think that's clear in the briefs, that in terms of the motion to disregard the genetic testing, I think that was fairly well summarized, that if there was a case for this is not it. This is a father who the court had found didn't have a relationship with the child. The court, I think, acknowledged that whatever the statutory factors in 608 regarding the relationship between the declarant father and the child really weren't at play in this case because there was no relationship. In terms of the statute of limitations, the only other thing that I'd add, and I think we pointed out in our brief that the father in this case was not an enumerated party listed under that statute, and therefore the 4-year, not the categorical, but the 4-year didn't apply. I think it's equally and too important that the child, too, was not included as one of the parties there. And if we apply a 4-year statute of limitations, because the child also has a right to come in at some point and say, if the child becomes aware that that they have a biological father, under counsel's interpretation of that statute, the child would have to be 4 years old or be forever barred from bringing this before the court. The child is not enumerated and the child has a right. I don't know if the court.
I assume counsel's gonna concede that during a period of minority, it's told.
I
Well-
concede that.
But I think I think it stands for the proposition, at least, that those were specific to the enumerated parties, the folks that were aware that the declaration was signed, and or rest that should be aware. The biological father may not be aware, and I think that's why we have the 606 provisions that say really, and I understand that pertains to a declarant father and a putative father, but I think it equally applies in a case like this where the father's not enumerated. They shouldn't be put to a 4-year statute of limitations because they never may have been privy to that declaration. With that, I'll submit unless the court has any questions.
I don't see any, thank you. We'll go to rebuttal.
As to the 4-year statute of limitations and a biological father not being privy, there's all sorts of rules when it comes to the discovery rule and when the clock starts and tolling when they're a minority, and I think that takes care of all the policy concerns asserted by the GAL. Your Honor's expressed concern at that this January 2023 order that declared biological father as the father of child changed the landscape of the case. But that's not really the standard when we're talking about whether an order is final or not. And the fact that, within 60 days you have to adjudicate that parent as under the jurisdiction of the juvenile court and as the parent of the child. That is the point where the case becomes final. That is the point where we have the court making an adjudication that yes, this guy is the father of the child, yes, he's under the jurisdiction of the juvenile court, yes, the child is under the jurisdiction of the juvenile court, and yes, we can move forward. And so because the adjudication necessarily has to happen after every determination of parentage and a motion to intervene, everything can be resolved at once the adjudication order is appealed. I also want to push back a little bit on the state's assertion that declarant father doesn't have any interest in this case. There were no evidentiary hearings in this case, and there's lots of allegations flying back and forth between the parties about where declarant father was when the child was conceived, what happened to him, and whether and to what extent mother let biological father know about declarant father and about the child. Because there were no evidentiary hearings, there weren't any declarations or affidavits attached to any of the motions, there was no evidence presented at all. So I don't think that this court can read into this record that declarant father has no interest in this child. I should also notice
But you're not disputing that he's deceased,
Oh,
right?
no, he
okay.
died, yes. So a child was born in
Okay.
2016, he died in 2017. But you can have an established relationship with a person who has died. Anybody who has had a parent who has died, or a sibling who has died, or a grandparent who has died, you can have a relationship with someone who is dead. And you can be taught at a young age about a parent who has died, and you can have a relationship with that person who has died. And that also neglects, also disregards that you can have a relationship with the declarant father's family, grandparents, siblings. You can have grandparents in your life because of declarant father. So we shouldn't just sweep away declarant father and say, oh, he has absolutely no interest in this case, because that's not true. And when a child has grown up for her entire life knowing that being taught that she has this one father who stepped up and said, yeah, I'll be your father. And then just take that away and say, oh, by the way, here's your biological father who hasn't been involved in your life and shown no interest for years. That can be very damaging to a child. For these reasons, we ask that this court reverse.
Well, we will take this matter under advisement. You all have given us plenty to think about. And we'll issue an opinion in due course. We appreciate the briefing in this matter. And I just want to make sure, obviously, we can issue an order after. I don't see the need for it, but does anybody want to speak to whether they want a supplemental briefing on plein air?
Not at this time.
Okay.
No.
There you go. We'll be adjourned.
All right. But I can change my mind.
Yes.
This court is